I'm much better now, so I can.
But in the wrong bench, you are. It's not organized matters, I suppose.
No, it's not a small matter. It's a small matter. Will not take time.
Yes.
May it please your lordship, my lord, as regards item number 2, my lord, I have talked, they have filed an affidavit in 2025. No, Mizoram.
Just wait till it's 2019 matters. Unless I look at the records, I am not adjourning.
My lord, because on the affidavit, not on adjournment, because the issue is that Mizoram matter.
From that, but this 2019 matter, unless I look at the record, I am not adjourning.
Only thing is this, because my lord, it has virtually become infructuous. I have written a letter to the client.
No, that's okay, but if we just 2019 matters, we are under.
No.
Yes.
May I please the lordship? My lord, present petitioner before your lordship approached by filing a writ petition, my lord. He was declared, my lord, foreigner of, my lord, 1966 to 1971 stream, my lord. And the lordship was pleased to issue notice, my lord. And in the meantime, my lord, he approached before the, my lord, concerned registering authority to register his name, my lord. Then, my lord, it is a statutory provision, my lord. Even then, my lord, this authority declined to consider his, my lord, application. And therefore, my lord, I am paying one unlisted, my lord, IA, my lord. Otherwise, 2 months will be completed, my lord.
It may not be today, tomorrow.
My lord. I am deeply obliged.
Question is item number 2, my lord. Yesterday, filed a requisition for adjournment, my lord. Yesterday, my lord, I filed a requisition for adjournment, my lord. Item number 2, concerned advocate.
No, we will have to call it. It's a 2019 matter. Without looking at the record, we are not adjourning.
May I please, your lordship? Item number 5, your lordship. Item number 5, your lordship. The council is engaged in urgent CAT matter. Kindly adjourn the matter for today.
2019 matter, we are not adjourning without looking at the records. We'll have to wait. Yes. Wanted to say something?
I'm praying for listing of a contempt matter tomorrow. It was there in yesterday's list.
Supplementary list, item 12.
But after the advisory report, he has been released.
Also for the petitioner. Also heard CGC is there. P. Sharma, then at CGC for the respond numbers 1 and 2. Mr. D. Nath, then a senior government advocate appearing for respondent numbers 3 to 13. Has submitted that he has received written instructions dated 17/3/2026.
I have given 2 sets now.
To the effect that the advisory board constituted under the PIT NDPS Act of 1988 found no sufficient cause for continued detention of the detainee, namely, Lokeswar, LOKESWAR, Lokeswar Sinha, pursuant to detention order dated 19/9/2025. Why did its report dated 2/3/2026. So it is submitted that he has also received next, it further submits that as per the WT a copy of the WT message received by him, which was provided to him, comma, the said detainee was released in connection with the detention order dated 19/9/2025. To stop, however, comma, he is still detained in the Central Jail, Nagaon, in connection with Hojai PS case number 358/2025 under section 21 within bracket. Indicate.
Advisory board is limited, the detention को कब release करोगे? If he is not required, ये नहीं आता.
Small b. Big 27. Within bracket small a of the NDPS Act. Accordingly, having heard both sides, the court is of the considered opinion that the challenge to the impugned
My lord, 19/9/25, my lord.
Page 29.
detention
30.
order dated 19/9/2025 has become infructuous. Accordingly, this requisition stands closed. You are still under detention in another case.
But the advisory board's opinion is like that detention in this case, if not required in any other case.
No, that's okay.
Lot.
You're not saying anything.
Lot.
Oblige, my lords.
But it is habitual offender. How did the surprising that you have not challenged that? Next.
Daily list item 1 for most orders.
In this case, your lordship, the affidavit wherein respondent has bringing the report, lordship, annexer B, page number 58, affidavit,
Page
lordship.
number.
Page number 58, your lord. This is the FIR, lordship, wherein content is there lodged by the informant side, lordship. There is a dispute between the parties, lordship. There is a commercial dispute. It is absolutely right, the paid amount has been credited into the informant account, lordship. But your lordship, in the said FIR, lordship, page number 60, last page of the FIR, lordship, wherein informants played before the authority, may I please to read. The view above, we request you kindly to intervene in investigate the matter and help us to get the amount recovered from Bikul Bora, proprietor of Messrs Soraighat Security Services at the earliest, so that we can pay the amount to the legitimate receipt, that is Messrs Silence. So it is absolutely right that police has no right to recover of such amount from the informant side. There is a commercial dispute and our statute has framed such law, lordship, for recovery of such amount, lordship. Then in this regard, police has no right. The police has well known about the fact that, but the very unfortunately, without sending the statutory provision
What is
notice.
the dispute? What is the dispute between you and the other party?
So, your lordship, in this case, lordship, I am the proprietor of Saraihat Security Services. I have provided 8 number of security services into the respondent, into the informant side, informant companies. But it is stated that due to the wrong transaction, maybe wrong transaction or may not be, it will be decided by the authority itself. Our authority has set up the form, lordship. But in this regard, the amount has credited into my account. I admitted the fact that. But police has, without compliance the notice, without issuance of mandatory of notice 35(3), lordship, as per BNSS Act. Just after 2 days, lordship, I was brought from my houses into there another affidavit in opposition filed by the respondent number 4 and 5, wherein stated that in para number, in paragraph number, in page number 40, subclause D, para number 3, subclause D, mentioned that. May I please to read. That during the course of preliminary inquiry, instant deponent made several phone calls to Sri Bikul Bora, but he did not respond. On 12/4/2025 at about 4:16 p.m., WhatsApp message was also sent to Bikul Bora on his mobile phone number so-and-so, and he was.
Where are you reading? Which page you are reading?
Lordship, affidavit in opposition filed by the respondent number 4 and 5. That is the earlier 2 number of affidavit has been filed.
Give us the page number.
Page number 40.
14.
40, your lordship. Para number 3. The 2 number of affidavit has been filed by the government. The first affidavit, Lord.
Yes, please read.
Page number 40, paragraph number 3, subclause D. Yes, sir. On 12/4/2025 at about 4:16 p.m., WhatsApp message was also sent to Bikul Bora on his mobile phone number so-and-so, and he was asked to contact the EO. However, there was no response, having no other alternative. On 12/4/2025 at about 5:30 p.m., the EO along with police staff brought Sri Bikul Bora from his home to Dispur police station for the purpose of inquiry. Just after 1 hour 15 minutes break, after sending WhatsApp message, the police personnel were arrived at my house and I was brought from my houses. So it is absolutely right that I am willing to cooperate with the investigation agency, but no sufficient time has granted to me. So that the mandatory issuance of notice under section 35(3) BNSS Act, the Honorable Apex Court into their in various judgment number of times categorically mentioned the statutory provision should be compliant by the investigation authority in any point of time. Any offense up to 7 years or below 7 years. So there is a commercial dispute.
Yes.
Well, it is absolutely not correct, Malad, that my respectful submission before your lordship is not. Lordship, may kindly see the Lord, I'm just placing that. But the prima facie, Malad, the FIR which lordship, the FIR is available, Malad, at page number 58, Malad. Prima facie is discloses, Malad, a offense of cheating, my lord.
Yes.
Kindly come to page 58, my lord. लो जाता तो लोग ना। Well, the plain reading of the FIR and which was, we have mentioned in the GD entry 54, that we have annexed, it prima facie seems to be a case of cheating, under section 318 of DNS. Lordship may kindly come to page 58, Lord. The FIR, I may be allowed to read, Lord. But the FIR states, Lord, that we'd like to state that since recent past few days, we have been facing a very critical situation regarding wrong payment to MS Sauraigat Security and Services and non-refund of the amount to our bank account by the party. The entire issue in detail below. Our company is working inside Numaligarh refinery premises in our 2 contract jobs in Numaligarh refinery expansion project for last 18 months. MS Sauraigat Security Services office address so-and-so has been supplying 8 number of security guards inside Numaligarh refinery premises in our 2 contract sites for last 17 months for our project material security. The proprietor of Sauraigat Security Services, Sri so-and-so, and as told by him, is an ex-serviceman from defense. We have another agency named Sarans Heavy Lift India so-and-so, from where we are hiring crabs.
Can you also assist us by reading this section 420? I am more acquainted with 420 than the new BNS.
Not
Can you please read the equivalent of BNS and also shows the ingredient
Lordship.
of cheating?
318 too. BNS.
That's why
Lordship.
ingredients of cheating.
Malad.
First line of the FIR says the critical situation regarding wrong payment.
No,
How a wrong payment can be cheating is
No,
that ingredient.
no, wrong payments, but subsequent conduct of the petitioner, present petitioner. Kindly, Malad, it's page 59.
No, I know. You see, what happened was, is just 2 days back, me and my sister, we were having this chana outside. I wanted to pay, but my sister paid. I took the food and she paid. Wrongful payment.
No, here, Malad, the case is different. Kindly see, the FIR discloses that he has withdrawn rupees 20 lakhs from that account. And he has distributed the amount.
See, in my account, if money comes, what happens to that money is my lookout. If you deposit money in my account, would it be cheating?
No,
So
no,
far as
Malad.
you are concerned.
Lordship, kindly see, Lordship, kindly permit me to just.
Then you see, then what you are doing is you are exposing all the Indians, all in India, to the offense of cheating. If my account is known to everyone. Half of my High Court knows my account number because my salary, my salary comes there. So you deposit 10 rupees and then cheating.
No. Malad, wrong deposit is not cheating. Malad, he knows, he was informed, he undertake that he has undertaken that I will refund the amount.
PDP, this is
Malad, kindly see, ultimately when this information in detail that he has undertaken to return, but now he is withdrawing, he is distributing the money to others, he is not giving the money. Ultimately, the information has come to police. Malad, kindly appreciate one thing, Malad. When the information in detail, page 59, Malad, the relevant part is, what he is doing.
We are trained to understand first the ingredients.
But the
of the
ingredients are there.
What?
But if
See
the,
that?
but
Please fit in anywhere in this 420 or this BNS. Anyway, please fit in.
Malad,
the fitment.
318, kindly see, Malad, 318,
Into the fitment.
Lordship. But an FIR has come to the police. At the first instance, Malad, ultimately they have to keep the FIR. If they don't accept the FIR, the paper, again, Malad, it will be against the police, Malad. So they have kept it, and for the purpose of preliminary investigation, they call the person.
against whom the complaint has come. And it is not a case that on 12/4 only he was informed, but from 9/4 only he was in the affidavit, he has read only para B. Well, para B, I'll read, my lord. Kindly see, my lord, para section 318.
See, first,
318.
first is the ingredients.
Lordship,
Right up here only.
Lordship,
Cheating.
whoever,
By deceiving any person fraudulently or dishonestly
Lordship,
induces a person so deceived to deliver any property to any person. That is the first line.
Lordship,
Now, wrong payment, is it by induction? That nowadays you get this, all this push mail comes and then you click one and then money goes to that account. We can understand that is deception. Is there a case of deception here? That
No.
he gave a link and he
no,
connected to that link and the money went away.
no, my lord, no. But kindly see, here, my lord, he was informed that,
Fraudulently induced, no. Information is subsequent. Subsequent event doesn't create cheating.
but he admits that the amount is with me. It has come wrongly, but it is with me.
I also
I'll,
admit, yesterday my sister paid money. I admit he has paid.
no, my lord, he has said that, yes, I will return. Then he is not returning the money and
Non-return
he is
of
using the
is
money.
Cheating.
My lord, if someone, if
Any
someone,
authority on the point, demanding money and non-payment is cheating.
no, my lord, my lord,
Even you can, in this case, you can cite us a decision even by a judicial magistrate second class. The non-return of money,
no, my lord, lordship may not stop in the that only, my lord. The subsequent what has happened, because the FIR doesn't come,
is a
On the-
subsequent action cheating.
my lord, kindly see, the FIR, my lord, I'm not justifying the FIR. I'm just,
It's not the FIR, but
Lordship.
the conduct of the police. Now, is a subsequent action amounts to cheating.
but in any case, kindly see, this has happened on 21st of March.
I have borrowed money from, at my school college time, I have borrowed money from hundreds and did not return.
No, my lord, kindly see, my lord, the FIR contains,
Pays that small amount, there will be hundreds of people whom I have not returned.
no, my lord, what is before the police? Kindly appreciate, my lord, what is before the police? But they said in the FIR that on 21st of March, something has happened. Then bundle of facts are there. Everything they have on 9th of April, they have placed it before the police that this is going on. Knowing very well that this money doesn't belong to him, he is utilizing the money, not returning to us. So this is what they have placed before the police. Therefore, for the purpose of investigation, my lord, he was contacted. On 9/4, my lord, he was contacted, he did not respond. In the affidavit, we have in detail said, my lord, not only on
Does
12.
any authority say that you call someone and if it doesn't respond, that notice under 50, sorry, that 35 is waived? Any authority on the point?
No, my lord, for the purpose of, I would submit, my lord, for the purpose of preliminary inquiry, my lord, they can call, my lord. Now, if lordship kindly comes to section
What is
173,
happening? People give a call that I am the police, you are under digital arrest.
no,
This call comes to me also.
this is,
No, just trying to understand.
my lord,
So will somebody be obliged to go to a police on a phone call?
my lord, informations were given to him. Ultimately, what the police will do then?
That's why I'm asking you. You see, did the policeman give him a message identifying himself and then giving a call? I receive hundreds of calls which I don't attend.
But under
Three
173,
people calling me that you are under digital arrest.
no, he was not arrested
Every
in
now
this
and
case.
then I am digitally arrested.
But those are fraud calls, my lord. Nowadays,
Will I be
coming up.
will I be obliged to go to a police station just because somebody has called me?
But for the purpose of police, for the purpose of preliminary inquiry, if the police is, my lord, is restrained from,
Can't call in the police station. Preliminary inquiry is go there and do it. You can't call somebody.
But-
Have him sit in the police station, issue a check in the police station.
my lord, he was not alone there. That is, he was not alone.
Hundreds of people are there.
My learned friend advocate, his counsel was there, his son was there, my lord.
There will be hundred of witnesses there in the police station. Is the police station a place to negotiate and then issue checks inside the police station?
But the
Is it a
parties,
facilitation counter?
the parties at their own will, my lord, have done that. We have
Now
not,
you're in trouble.
the police has not forced, my lord.
Now you're in trouble.
Police has not forced. Police has not forced them.
But why did you do it in police station?
My lord, though the parties, they
You're
were
aware of the
there.
term superior bargaining power in a police station. Who will have superior bargaining power? You call someone without notice, he comes in. You see, if you are called to a police station, you go to a police station, are you carrying a check with you?
My lord, kindly allow me to read para 2D, my lord. P B, my lord.
This ingredients are there. How do they create an offense?
No, offense, my lord, they have therefore, they have, till that time, my lord, they have not registered the case. Because
That is more
when,
serious. That is more serious. Without registering a case, you have called someone.
for the, my lord, under 173, my lord, they can, my lord, before registering, my lord, they can, my lord, see whether there is a substance or not. They can verify, my lord.
Right. But then it could be anything. It can be anything.
No.
Mr. Nath is sitting here, he is a bit annoyed with the court question. He looks at me very sternly. So is that, I can perceive it to be a threatening. Can I lodge a FIR in the police station and can the police people call Mr. Nath and then on an allegation that preliminary inquiry, why you look like this big eyes, the judge?
Criminal law does not become as a weapon.
Register a case and then call someone, then the preliminary inquiry. Just preliminary inquiry say that under any police manual, does it say no case is to be registered?
My lord,
Even a preliminary inquiry has to be numbered, the GD entry has to be made.
yes, GD entry has been made, my lord.
Where is that?
GD entry, my lord, GD, in the GD it was entered, my lord.
Where is that?
Yes, my lord. In the affidavit, my lord, kindly come to page 55.
Next, sorry.
Page 53. Page 53, you have said, my lord. Relevant GD, lordship will find a page 55. GD brief, my lord. On 9/4/25, complainant so-and-so Offshore Infrastructure Limited lodged an FIR at Dispur PS stating that since past few days, they have been facing very critical situation regarding wrong payment to so-and-so and non-refund of the amount to their bank account by the party so-and-so. This was on 9/4/25, complainant so-and-so Offshore Infrastructure Limited lodged an FIR at Dispur PS stating that since past few days, they have been facing very critical situation regarding wrong payment to so-and-so and non-refund of the amount to their bank account by the party so-and-so.
This is an echo, Mr. Mishra.
But,
Mr. Mishra, it's only an echo.
but
It shows that we are hearing him intently. আগতেও হৈছে এইবাৰ আগতেও এবাৰ হৈছিলে okay, we got the answer what did happen. The live telecast is delayed by about half a minute, so that live telecast caught it and then it was displayed. It's okay. It's a small glitch. It was a echo not from the system, but it was an echo from the live telecast.
Right.
There's a time lag of half a minute.
It is not on real time.
Huh?
It is not on real time.
No, it's real time, but transmission does take time. It goes to the main server and then it goes.
Few seconds, by few seconds.
Okay.
Lots of. So, this is the GD entry they have entered, and ultimately, if we have explained in the affidavit, para 3, it's clear for my answer. Yes, yes. One, kindly come to 173. This is not the 178, not the power to hold investigation of preliminary inquiry, the magistrate on receiving report under 176. 3. Yes, Lord. Without prejudice to the provisions contained in section 175, on receipt of information relating to commission of any cognizable offence, which is made punishable for 3 years or more, but less than 7 years, the officer in charge of the police station may, with a prior permission from an officer not below the rank of DSP, considering the nature and gravity of the offence, proceed to conduct preliminary inquiry to ascertain whether there exists a prima facie case for proceeding in the matter within a period of 14 days. मतलब but kindly allow me to give the date. GD entry, first GD entry was made on 9/4. He was brought to police station on 12/4. No, kindly permit me to say it. Lordship is in 12/4. Yes, Lordship is indicating the page number 757. 56 is the GD entry, first GD entry. Lordship. But I have brought here the GD entries. 54 is the initial because he said that without any GD entry, some complaint has come without entering GD entry, this has come. The second GD entry when he was brought, to police station on 12/4, that GD entry I have placed. Lordship. Lordship. It, kindly see, page number 60. Page 60 is the FIR, in that copy only. After receipt of this, the officer in charge, kindly see, they received by dispute PS GD entry at the bottom, received by dispute PS GD entry number 54, dated 10/4/25, and entrusted to Kamal Thakuria to cause an inquiry as per section 173(3) of BNSS and submit a report within 40 days. He was directed. Lot. Lot. That's right. Okay, it's a centralized, but there is something, because from this only I am referring to that. So the officer in charge of the police station, he has entrusted one SI, SI. It's a it's a thing to be looked into. That's true. That's but BNS. But for a for a moment, Malad, I'll try to satisfy your lordship, Malad. Kindly permit me to read three four paragraphs of the FIR. Kindly see what has happened. Because on 21/3, the money got transferred. Kindly come to page 58, Malad. I'm reading three paragraphs, Malad. The last paragraph, page 58, Malad. The mistake could be understood by our account staff only on 25/3/25. No,
You remind me of an incident which was argued in this court, old court number 7. It happened about 20 years back, or maybe 25 years back. I have said it here, I think. You see, at one point of time in Gauhati, there was a
Lordship, ultimately, Lordship has to see the action, because while deciding this writ petition, Lordship will see whether the person was wrongfully confined by police. That is the issue before your Lordship. Ultimately, after submitting everything, I have to submit that only, whether he was wrongfully confined. Because that is what the point here Lordship will issue, because he has three prayers. Two prayers, Lordship, I'll submit, Lordship, there is no necessity to decide. Lordship's adjudication is not required on those two. Lordship. But in the morning hours, next day. And by 7, everybody left. The police officer, SI, who was entrusted to investigate, he was not present at that point of time. He was not there, and they left. On kindly see the dates, very important dates are, on 13 that has happened. The GD entry I have annexed, it is closed because ultimately the parties have resolved their issues with India. On timing. He was taken to police station, George. Lordship. Yes. Yes, Lord. Next morning, 7.
5:50 AM. Okay.
But it was not wrongful confinement. That is what I'm trying to submit. But he was not handcuffed. He was not inside the lockup. He was with his son, with his lawyer.
So subsequent
They
states, lordship,
state,
where
in
was
fact,
when?
the video footage is there.
Your lord, your lord, lord. 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 Again. Sorry. Sorry. Your
But the lordship has called for the CCTV footage of the police station. The CCTV footage are very clear. Lordship. Lordship. Son, and he was having the phone. But his privacy or the for the wrongful confinement, his in the affidavit, no, in the lordship, what from the affidavit, what I am submitting, Lord, that the complainant, the representative of the complainant, they had a talk, the representative of complainant, he was on the way, he was coming, that is why he stayed. Lordship. Lordship. I can't go beyond the records, whatever available, we have already placed in the affidavit. No, police cannot, police. Last para page 58, page 58, annexure B. The mistake could be understood. Yes, no. Page 57. Logic. Logic. This part, I have some reservation. I don't know. Otherwise, the case is closed. On the record shows are on 13 floors. OC he arrived at 8:30, but before that this has happened. Ultimately in the GD entry, it was entered. No, before this particular time, all have left. I have in the affidavit I have stated. So, Lordship, I'm reading the FIR, the last paragraph from page 58. The mistake could be understood by our account staff only on 25/3/25, while Sarens was complaining about non-receipt of payment of rupees 29 lakhs and cross-checked the online transaction records. The payment was made on 21/3/25. Kindly take note of that, my lord. Upon knowing the mistake, we immediately emailed MS Bikul Bora so and so on 25/3/25 mentioning wrong payment and requested him to refund the amount of rupees so and so to our following bank account wherefrom payment was transferred. We also called so and so over his mobile phone several times and requested him to refund the amount as soon as possible. Initially, he responded the calls, but later he avoided to attend the calls as well as did not respond our WhatsApp messages on also. On 29/3/25, Sri so and so sent a mail to us trailing to our email dated 25/3/25, wherein he admitted about the receipt of the said amount and he sought few days to refund the amount. He verbally informed that he will refund the payment by 2/4/25. After that, Sri so-and-so stopped to respond phone calls and WhatsApp messages from our people. Then our people tried to contact him in his office address at house number so-and-so, but the office was closed. And the nearby people of his office told that the office is rarely seen open. Then our people could get his house address from their office neighborhood and visited his house address at so-and-so, where they met Sri Bikul Bora's daughter, and they could know from her that so-and-so was not present at home at that moment. On request to our people, the daughter of so-and-so called her father from her mobile phone, and through her phone, our people could talk to Sri so-and-so. On phone, Sri Bora assured to meet our people, visited his house in the evening, but he did not come up as he committed. Instead, he sent a message in WhatsApp to meet them on 8/4/25 between 2 to 3 p.m. and committed to refund the money. When our people contacted him at 3:32 p.m. and inquired about the proposed meeting, he said that he is coming shortly to the meeting point at our people at Jew Road so and so. He come to the meeting point at about 4 p.m. wherein he told the following, that he has withdrawn cash of rupees 20 lakhs from his account in Indian Bank so and so on 25/3/25. He has distributed the cash to various parties whom he owes dues. He will refund rupees 15 lakhs on 9/4/25 by online account to the office bank account. But there is no such contract between them. No. No, but there were specifically a contract between those two persons, and it is upon the quality of service that will not come. Here, can you see here? No. Ultimately, with this bundle of facts, they come before the police. So when a written complaint has come to police, the police has to see what has happened. Therefore, the preliminary inquiry. Immediately, they have not registered a case under any section. So the conduct of the petitioner, ultimately that has clouded the thing. Ultimately, what has revealed from the FIR. Therefore, the complaint came to police, and police after receipt, if they simply say not, or they refuse to accept it, so these are the under these facts and circumstances, they lodged the written complaint before the police, written FIR before the police, and after receipt of the FIR, at page 60, I have read already that a GD entry was made, and the officer in charge has directed the SI to make a preliminary inquiry. Now, kindly come to our affidavit at page 38. After receipt of that on 9/4, what the police has done, we have explained. They have alleged. In fact, I have taken the word from the FIR. If it is cheating, yes. Offense is imprisoned for 7 years. Maximum is 7 years. Compounding. Logic. 7 years. Kindly take kindly see, my submission is that with that facts and allegation. But whether it is a cheating or not, in the FIR it is alleged that it is a cheating. Police got that information, started the preliminary inquiry, and under 175. No such report has been made. No such report has been given, and it is by the OC is there, page 50, page 57. well, the OC, as I have submitted, my lord, well, under 173, my lord, before registration, they can therefore to see whether the offense is there or not, they can have an inquiry. Well, during well, I have taken your lordship to the FIR to place it before your lordship that when this information has come to police, the police has entered a GD and called the petitioner for an inquiry to know what has happened. But during the inquiry, my lord, no, the settlement was not done by police. It was between them, the complainant and the petitioner. Complainant and the petitioner, my lord. Lodge. But the well, of course, after the inquiry materials are there, they are bound to register a case. Lodge. But I leave it to your lordship, my lord. The paragraph 3 of the initial affidavit at page 38, that is the explanation given, my lord, along with the record, my lord. I'm placing it before lordship. Lordship, kindly consider. My lord. Okay. Well, gotcha. of letter law. Ji, Prem. Malo. 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 I'm just placing that there is not a wrongful confinement on that logic. 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 Malo.
Supply item 13.
Look, I've taken consent from, the lawyer appearing for item number 13. Mine is 14. 13 will take some time. If it is not inconvenient, if your lordship can take it. 14. 4.
Where's Arjun? In fact, my lord, in the morning when I saw him, I felt very happy. And I suggested, sir, why not you do it early? We'll do it later.
Very nice. Courtesy.
Correct.
There's no more nicety now, like Panna has shown.
In fact, number of seniors like him are also decreasing. That is the problem.
May I please, your lordship? My lord,
Item 14.
my lord, this is review of your lordship's judgment dated 20th June 2025. Now, my lord, on 2 grounds, I have filed this review petition. Number 1, error apparent on the face of record. And judgment and order under inadvertently, my lord, overlooked the law laid down by the Supreme Court. Your lordships, in your lordship's judgment, your lordship has clearly held that the discharge order was punitive. If your lordship can kindly turn to page 99. 99. My lord. The other day, I've seen your lordship has directed a petitioner to continue in a contempt matter.
Yes.
So the other day I saw. My lord, if your lordship permits me, just shortly I'll put what is the case. My lord, your lordship has repeatedly held in your order that the discharge order is punitive. It is violative of Article 311(2) of the Constitution. Your lordship has also held that there cannot be any difference, or Article 311(2) does not make any difference between a probationer and a permanent employee. But at the same time, my lord, inadvertently, what was done, if your lordship can kindly turn to paragraph 140. 140 at page 144. The relevant is clause 7 at page 146. My lord. I understand, and if your lordship remembers, I said there are a lot of pressure on your lordship. No, pressure in a sense your lordship wanted to dispose because the teenagers was retiring. That was the pressure, I mean. It was not other thing. That other thing will never come, I know. Now, 146, if your lordship can see, page clause 7. If there are any appellants, your lordship got 146. If there are any appellants whose provision has not been completed, that would not become entitled to reinstatement in service. However, in respect to those appellants who the competent authority in the government shall pass appropriate order to withdraw the respective discharge order already passed and substituted, and the said discharge order with the simpliciter discharge order of not having found them fit for confirmation so that a stigma would, no stigma would be attached against them. Now, Your Lordship, the very purpose of lifting of veil. Now, lifting of veil, if Your Lordship remembers, the lifting of corporate veil was the first thing. Because in the company, my lord, some companies are formed to defraud the creditors, where it's all the shareholders are the shareholders of the company, majority share. So doctrine of veil was, my lord, first applied in the company laws to see the true nature of the company that has been formed. Now, that was, my lord, incorporated in the service law, because order simpliciter will be passed in respect of temporary employee or a probationer that you are not fit to continue. And that's the end of it. But actually, the order is passed on the basis of some allegations made. There's so many cases. Therefore, my lord, the Supreme Court brought this doctrine, made it applicable in the service law, that will lift the veil to see whether the order is punitive, violative of Article 311(2) of the Constitution. And Your Lordship has done that in this case. Your Lordship, madam.
For example, when you are making that submission, for example, a person whose probation is not being extended for various reasons. Supreme Court has recently said that it can be simply cited and then the past record would still be discharged simply cited. If I find someone who is a probationer not up to the mark, we make a note of that. And then we say that we don't extend the probation period. So for that, Supreme Court says that it still is a simply cited.
No, it is. In fact, my lord, there are cases where the employer has proceeded with the inquiry, and then he says, why should I inquire into the matter? He is a probationer, and inquiry was conducted to see whether he is suitable or not. And the inquiry report says he is not suitable. That will be a different thing. Here the case is that I got myself appointed fraudulently by resorting to colossal fraud. And if that is so, then Your Lordship's own this thing, my lord, Your Lordship will see paragraph 138, at page 138, paragraph 138. It starts from
Yes.
Now, let me see what Your Lordship found. Just 2 paragraphs. My lord, first of all, Your Lordship will kindly come to page 122. 122. Paragraph 111, my lord. Therefore, even, my lord, even assuming that the appellants were probationer, yet when their discharge order is bad, is based on foundational fact, and the material available against them was not the motive to pass orders against the appellants were found entitled to protection envisaged under Article 311 of the Constitution. In that case, the government has not recorded its satisfaction in writing as to why it was not reasonable, practicable to hold inquiry. Clause B of the second proviso of Article 311(2) is an exception and not a rule. Therefore, the same must be scrupulously followed, which was not done in this case, which was found to vitiate all the discharge order. See, your order, Lordship, is saying the discharge order was bad, is violative of Article 311(2), and therefore discharge order is bad. Now, your Lordship's direction that you withdraw the order which is stigmatic and pass a simple order would amount to saying, okay, you camouflage it. Now, in Hussain Bhai's case, that was Krishna Iyer's judgment in 1978, it says what the court should do if it finds that the order is violative of Article 311(2), or it's a punitive.
But then a bad order open for.
No, that now there again, I could understand, I anticipated this. There are two decisions on the point, which has been referred in a decision of this court, Supreme Court, in 2006. One is, if your Lordship see Order 47, Rule 1, it also contains any other sufficient reason. Now, any other sufficient reasons would mean a region which is analogous to analogous to regions apparent on the face of it. Now, here, this case, Miller, Supreme Court has said that the very purpose of lifting the veil is to see whether the order is punitive or order is not punitive. Now, once your Lordship finds that this is violative of Article 311, and then your Lordship says, then it becomes something, my lord, which is an error apparent on the face of record. Now, kindly come to, my lord, page 122 only, my lord. If your Lordship will have read it, just above that, third line. Third line, below. Therefore, on lifting of veil, my lord, got it. The observations made by the learned single judge in paragraph 43 to 48 of the judgment leads to only conclusion that the state government at the highest level had arrived at a conclusion that the appellants have secured job allegedly on the basis of colossal fraud. Then there can be no other conclusion that the same formed the foundation of discharge order. Now, thereafter, your Lordship will come to the single judge, my lord, having found that the orders were stigmatic, violative of Article 311(2), did not interfere because he distinguished, my lord, between misconduct pre-recruitment and misconduct post-recruitment. That has been rejected by your Lordship. Your Lordship will see at page 139. It starts at 138, 139. Fifth line from the bottom of page paragraph 1, 138(1). Therefore, this is your Lordship's finding. Therefore, the finding of the learned single judge that appellants have secured appointment as probationer due to colossal fraud, the discharge of misconduct as pre-recruitment phenomenon is found contrary to the requirement of Article 311(2). So that portion of the learned single judge's conclusion was rejected by your Lordship on the ground that Article 311(2) does not discriminate between a probationer and a permanent employee. And your Lordship has specifically mentioned that at page 146. 146. 7 is part of the paragraph 140, which I have just placed. I'm sorry. My lord, I'm sorry, at page 143. At page 143, paragraph 139, 138, 9. At page 143, my lord, can kindly see. In the light of various decisions, in the light of various decisions of the Supreme Court, of India, as discussed herein before, wherein it has been held that protection under Article 311(2) was available also to a petitioner, and in the light of the fact that nothing was placed on record to show that the authorities have passed any specific order as to the requirement of Clause B of the second proviso of Article 111(2) of the Constitution, the reliance on the decision of the Supreme Court of India in case of Palak Modi, Purushottam Lal Dhingra, Samsher Singh is not sustainable. Article 311 does not create any distinction between a confirmed and regular member of the service. Now, by this order, my lord, so far as those who have completed the probation, there is an order that they will be taken in service and then inquiry will be held. But in case of a probationer, my lord, yes, 131. Yes.
My information is that these before the Supreme Court cases are for final hearing today. Today. Those are sufficient. Lot.
No, it is here. It is here, madam.
It is clear.
Now, if it's a common judgment and that has been stayed, once, yes. But suppose, I'm just saying, suppose this stay is only qua Writ Appeal 131. If that is so, then suppose tomorrow they set aside in respect of that qua 131. Then a review, because our right to go will not be taken away to Supreme Court. Now, before no, what I'm saying is, as an abundant caution, because if we go there and show this, that after lifting the veil, the High Court found that this order is punitive, violative of Article 311(2), but still permitted them to pass order simpliciter, thereby the High Court has permitted them, okay, you now pass the order simpliciter, though we have found that it is violative of Article 311(2). Then they will say that this is a trivial matter, you point out to the court. No. Not on these grounds. Not on these grounds. And my lord, another thing, of course, I should not say this because others will get affected. These, except those 3 police officers, which case I did before you, there the probation was completed because there were certain actions taken by the government subsequent to completion of 2 years. In other cases, nothing has been done. And these probations of 2 years or whatever is period is there is not automatic unless it is maximum. Suppose the maximum period of probation is 2 years and one is allowed to cross that, then he can only be there after that as a confirmed employee. So that is automatic confirmation. But in all cases, there is a provision for extending. That's why I did not come under those things. I said, no, first I'll go, file this review, point out to your lordship, and then whatever is the result, then we will go to Supreme Court if required. Well,
I'll just have an update. Just now, I received a message that the final hearing has been postponed till 8th of April in the Supreme Court.
well, I was referring to page 146. 146. I'm sorry, that I have already referred. 143, paragraph 138, subpara 9, 143. Last two line, your lordship will say, I think I read it. Article 311 does not create any distinction between confirmed regular member of service and a probationer. Now, having said this, ultimate order is that there is a distinction. Your lordship made a distinction between those probations who have completed their probation and those who have not completed. So, therefore, my lord, that goes against the settled law and even your lordship's finding. Now, one decision I'll place before your lordship, which will say when review will lie. This is 2008 8 SCC. 2008 8 SCC 612. 2008 8 SCC 612. I am relying on paragraph 25 and 32. Page 634 is paragraph 25. 25, madam. 25 at page 634. In this case, a decision was referred by the Supreme Court, which was reported, it was a 5 judges bench of the federal court. In this reference is 1949 FCR, page 36. I'll place 25. In Harisankar Pal versus Anantnath Mittal, a 5 judges bench of the federal court, while considering the question whether the Calcutta High Court was justified in not granting relief to non-appealing party whose position was similar to that of successful appellant, held that a decision is erroneous in law is certainly no ground for ordering a review. If the court has decided a point and decided it erroneously, the error could not be one apparent on the face of record or even analogous to it. When, however, there is an exception. When, however, the court disposes of a case without adverting to or applying its mind to a provision of law which gives it jurisdiction to act in a particular way, that may amount to an error analogous to one apparent on the face of record, sufficient to bring the case within the purview of Order 47, Rule 1. Then your lordship will come to paragraph 32 at page 636. 636. I'll just place my note here. One decision, K. Ajit Singh Babu versus Union of India, Ajit Kumar Ras versus State of Orissa was referred to and quoted in paragraph 32. I'll just place the last two lines of paragraph 30, which is quoted and which is in italic. If your lordship will see, third line from the bottom of quoted page 30, third line from the bottom. It may be pointed out that expression, any other sufficient reason, used in order 47 rule 1 means a reason sufficient analogous to those specified in the rule. Now, my lord, the law laid down by the Supreme Court is a law under Article 141 of the Constitution, and it is binding. And I have, my lord, checked, subject to correction there may be, but whatever I have law is there, and I have referred it before your lordship. Starting from Sanset Singh, Dipti Prakash, Gujarat Steel, all those. Not a single case I have found that having found that the order is violative of Article 311(2), the court directs, okay, you camouflage it, pass and simple law. Therefore, this is a case of review. And I will specifically refer to one case, my lord, Hussain Bhai case, where Justice Krishna Iyer said what the court should do if on lifting of bail they find. I'll place that decision. It is 1978 4 SCC 257.
Some law must originate here also.
My lord?
Some law must originate from here also.
No. My lord, I can understand one thing, that the lordship is in so much hurry. I think only 2 days or some left for the privileges to retire.
2 days.
2 days left, and your lordship was hearing. So I can understand, my lord, the pressure. But then this is something, my lord, which can be reviewed. Lordship can review because this will end in the Supreme Court, that is for sure. Now, your lordship will, for paragraph 1, I will refer, my lord, for the facts. And this is a case, my lord, which saved the contract laborers. My lord, in the factory, what happens is canteen is run by the contractor. Now, they will employ some person on contract. And my lord, when they are terminated illegally or something, the management of the factory will say, no, they are not our employee, they are employee of the contractor. So how we are responsible? So this case settled that, my lord, contract labor case. It's famous for that. I'll place paragraph 1 at page 258. The petitioner before us in this special leave petition is a factory owner manufacturing ropes. A number of workmen were engaged to make ropes from within the factory, but these workmen, according to the petitioner, were hired by the contractors who had executed the agreement with the petitioner to get such work done. Therefore, the petitioner contended that the workmen were not his workmen, but contractor's workmen. The industrial award made on a reference by the state government was attacked on this ground. The learned single judge of the High Court, in an elaborate judgment, rightly held that the petitioner was employer and the members of the respondents' union were employed under the petitioner. A division bench upheld this stand and the petitioner has sought special leave from this court. Now, your lordship will come to paragraph 5. The true test may with brevity be indicated once again, where a worker or group of workers labors to produce goods or services, and these goods and services are for the business of another. That other is in fact the employer. he has the economic control over the worker's subsistence, skill, and continued employment. If he, or for any reason, chokes off, the worker is virtually laid off. The presence of intermediate contractors with whom alone the workers have immediate or direct relationship as ex-contractor is of no consequence. When on lifting of wage or looking at the conspicuous factor governing employment, we discern the naked truth, though wrapped in a different perfect paper arrangement, that the real employer is the management and not the immediate contractor. Myriad devices, half hidden in fold, after fold of legal form, depending on degree of concealment needed, the type of industry, the local condition, and the like may be sorted to when labor legislation casts welfare obligation on the real employer based on Article so and so of the Constitution. The court must be astute to avoid the mischief and achieve the purpose of law and not misled by the maya of legal appearances. Your Lordship will see the meaning of a statute, not a statute, astute. This is the judgment, my lord, which has saved a lot of workforce at one point of time. The factory owners couldn't exploit them as they were doing.
No, because under the Contract Labor Prohibition Act,
Yes.
the lifting of wage is permitted.
Yes.
This is for the beneficial use
Yes.
of the labor and
Yes.
the.
Yes.
So,
Those doctrines have been incorporated in the my lord, way back in the service law. Now, meaning of a statute, your lordship will see, having the ability to assess the situation and people accurately. Now, your lordship has found that the order of discharge was punitive, violative of Article 311(2), and therefore the only course left, in my humble submission with all respect, was to again permit them to pass an order simpliciter. Therefore, my lord, my submission would be that the form of the order is not conclusive, and your lordship has already found that it is violative. Therefore, my lord, it's an error apparent on the face of record, wherein your lordship has allowed them to pass an order simpliciter without mentioning anything else. My humble submission will be, my lord, that this matter requires hearing, my lord. I think Mr. Kohli will come, or you.
No, today, Lordship will issue notice for the matter. I'll accept that notice for the response.
the problem starts from here. Why? We'll tell you. You see, the classical school of entertaining a review requires that once a review is accepted, then the order is recalled. And
Not
then,
that, it can be modified.
no, then it can't be.
Because I'm seeking review of the direction under.
So therefore, what we'll have to do is that we'll have to you see what is it?
Not your lordship.
Classical school is that you withdraw the order, recall the order, and then
No,
do a fresh hearing.
not the entire one. I'm seeking review of that. Your lordship will either allow it to that extent or dismiss this review petition, that it is not mentionable. Then there will be further courts open.
So, but what is the classical school? Classical school is that the order under challenge has to be withdrawn. Then only
My
the-
lord, no,
Otherwise-
it has to be reviewed. Now, my lord, here is a case where there several petitions were there and all were heard together from different departments. The service rules were different. Therefore, your lordship will confine to 146 at page, paragraph 147, which is available at page 146. I'm seeking only that, not seeking because then I'll be committing suicide, asking this to be, the entire thing to be reviewed. That is not, either your lordship will accept it or reject it, my contention.
And in fact, my lord, pursuant to your lordships, the compliance order has been passed away.
That will not make any difference. Compliance order.
But that, again, not an appropriate time to make a comment
Lordship,
on that. Here, given is that order, earlier order is, Mr. Isha has placed it. This one.
but my lord, there is a dispute. They said that it is not there. They said. We said that it is passed, but they said that they have not received.
Since that we have already said here, we don't want to comment. Observation we.
Yes.
Agree to a date, both of you.
My lord,
Agree to a date, both of you, after view.
well, after view is,
How much time, Mr. Nath?
Lordship may give us 4 weeks time or lordship in the last week, my lord, on 27th or 29th. My lord.
28, 30, from the 4 to 4. Mr. T. K. Mr. Assisted by Mr. P. Prasad for the petitioner.
let it be on 7th May, my lord, if it is convenient. So those days, the cases have been fixed.
So, third, Mr. T. Nath, and it. Senior government engineer. You are appearing for all the respondents?
All three, my lord, all three.
For all the respondents. Next. In in light of the finding of the observations made by this court in paragraph 111. And paragraph 138 within bracket 9. Of the impugned order under review dated. The impugned judgment and order under review dated 26/2025 2026/2025 passed by this court in WA 98 of 2020, comma limited review is sought for in respect of the directions contained in subparagraph 7, Roman 7 of paragraph 140 of the said order. in respect of the petitioner. Next one. Issue notice returnable on, you want 7th May? 7th of May. 7th May 2026. Requisite extra copies of the date petition, sorry, the review petition, we said of the granted. Senior government advocate, within 2 days. You have a soft copy also?
Soft copy, we'll provide.
Including a soft copy thereof. Okay. 2 working days. We are making 2 working days, otherwise Saturdays and holidays will come in. No. Next one. Response, if any, by the state, the file at least 2 days prior to the next date of the state. List on 7/5/26. So we have limited the review to only that.
Only that. That's the
140.
only, yes, that's ground number 9, that's limited to that.
I've asked you because classically I would have withdrawn the order.
Before that, I would have made a request to let me withdraw that. We will both there.
That is how we were told about exercise of review jurisdiction.
No.
2 days before.
And if we are wrong, you are to be blamed.
In fact, our grievances is everything is in our favor in the judgment, but that's the only thing where we are agreeing and we are fine. All right.
Daily list item 2 for hearing.
All this matter, I think 30 is there. Item 15.
Item 13.
Maybe pass on the
Item
time.
15.
Item 2.
13. Yes.
Maybe the lordship, I'm led by Mr. P. Nayak, advocate, but just now, lordship, he had to leave the court for some lordship urgent work. Just now, he was outside, he was waiting the whole day, my lord. Lordship, it means your lordship may adjust for accommodate the matter.
Well, yes, waiting. This is the matter. Then tomorrow, because we'll be waiting for quite a long time.
Lordship, can I
To
take
accommodate,
entry
to
court?
accommodate you, yes.
Lordship, tomorrow, lordship is not available.
Then how can we go and accommodating?
Lordship, he was waiting, so just now, lordship, he had to rush, lordship.
How far we can accommodate, that's the issue.
My lord, in that case, make it 24, it will be here.
24, there are already many matters fixed. Then, many matters are there on 24. Video call. How many matters are there? Just check. 30. 30 fixed matters are already there.
26th.
26th. Huh? 26th. Also, the representative of the fair. the next date of listing, the matter will not yet joined. That's for all 26. 2026.
Deeply
You are
of the
joined on that day.
lordship.
The last time I said, my lord, luck, your lordship, that is what I said, luck. No grievance, no grievance, because what?
No, for us, it was still hard work.
That's true. Hard work, 99% hard work. There is no doubt about it. No shortcut. No shortcut. Nobody can say shortcut. Obliged.
Deeply obliged.
You want to know about shortcut, please be here in this bench, you will come to know.
The FT cases. I
You come to know. You will have a lot of shortcuts here.
Deeply obliged.
Item 2.
Yes.
Mission was made, my lord. Conducting council, my lord, is out of station. Conducting council, my lord, for the petitioner, he is out of station. Any, my lord, Tuesday or Thursday, my lord?
These Tuesdays, Thursdays can be accommodated. We have already lot of
lord.
matters. Except for Tuesday, that is anything. Next week, after, make it after Eid. 25th,
25th March.
25th of March,
My lord.
which is a representative of Pyramid and Council. From 25th to 25th.
All.
Item 3.
Yes.
My lord, here the issue is a memorandum of settlement was arrived between the state government and the Hamar People Convention in 1994. Thereafter, my lord, the councils were, the Hills Development Council was resultantly formed and it was continuing and extended from time to time. Again, on my lord, April 2, 2018, there was a second memorandum of settlement by which the earlier settlement has been superseded. And my lord, on pursuance to the second settlement, Act was formed in 2018. Till the Act was formed, thereafter, my lord, for limited period, the Singlung Hills Council was allowed to extend from time to time. Now, my lord, they have come in with an affidavit saying that in the meantime, lot of meetings has been taken place. There was no stay order. The Act has come into being. My lord, because I cannot say it becomes infructuous. My lord, can I make a prayer that this matter is transferred to Mizoram? From there, the registry will take care of that because I have sent my registered post. Nothing, no reply, nothing has come over. And the affidavit was filed on 18/8/2025 after 6 years. Because my instruction goes from the additional advocate general. She said that lot of elections has taken place and the council, whether it survives or not after the act, that instructions, my sister madam is there. If the matter can be transferred to Mizoram and it will be taken care of. Registry will send them a notice and I have sent a letter on my lord 19/8/2025.
Yes. Said it there.
Yes, Lordship.
As well as Secretary and State of Mizoram. appears along with Mr. P.P. Datta, sorry, the A. Balwa. Mr. A. Balwa, doesn't count. Next. Sorry, the additional the journal does not object to the play made by the learning partner for the petitioner to transmit the matter to for final disposal for the ISO bench, just permanent bench. Next one. We take note of the investigative endorsement made by the Honorable Chief Justice in a note dated 16/5/2019, allowing the permitting the writ petition to be filed at the principal seat. We also take note of another administrative order by the Honorable Chief Justice on 21/8/2025. Requiring the registry to allow the allow listing of the matter before Division Bench 2, Roman in view of the reason assigned. Right. Usually, after the initial orders that are passed when bench is not, when bench at the outline, but when bench at the outline, when the outline bench is not available. But when no division bench was available at so ideally the matter then the concerned outline bench for final hearing. Next, few of the set to note dated 16/5/2019 and 21/8/2025. Registry shall place the matter before the Honorable Chief Justice. To consider the prayer made by the learned counsel to the petitioner. And registry shall do the report accordingly. Accordingly, lay this matter before the Honorable Chief Justice on the administrative side.
Well,
You have referred here, but the justice take up on it. There's a one specific order not to be listed, not to be listed for DB2.
because my lord, before that,
Whatever the reason, but ultimately, it's the Honorable Chief Justice
take the decision.
take it.
Okay.
Item 4.
May it please your lordship. Actually, I am today, I am not in fit for hearing the matter. I am in fasting due to Ravana. So kindly please adjourn for a day. Next week, any day. I am feeling uneasy in my body. Due to fasting, I am fasting on the prayer made by lunch. Just again, you date, fixed date.
So 1 week.
On next week, on 26, 25.
24.
20,
20 April.
20,
20 April.
20 April. 20, okay,
30.
20 April, okay. Hello, miss. Item 5.
Item 5.
Requisition from the petitioner for interferences in my action today. Just again on. Item 6.
Item 6. Item 7. Item 8 with 9.
Well, this matter may be fixed at 2. This matter may be fixed at 2 here. It's next in another board.
Okay, next week. Next week, next week. Next week, any day. Next tomorrow.
May I please your lordship? Lordship, in item number 7, lordship, I was on next lordship.
Thanks.
Lord, lordship, in this case, lordship, the case record of the petitioner's death has not been received, lordship. In this matter, lordship, the case record of the petitioner death has not been received. Lordship, no, the TCR that has been received, that belongs to the uncle of the petitioner, lordship. He was declared as an Indian. Lordship. Yes, lordship. Lordship. Lordship.
the only conclusion would be that you are a happy family.
Lordship, the petitioner's father,
Show you something.
Lordship,
We'll show you something. Yes. You have given the flag. I'm not aware that this is a wrong record, but you put a flag.
Lordship.
Yes, this is the opinion in your uncle's case.
Lordship.
Your uncle does not even know your father. Your father's name is Habibul.
Lordship.
Habibul is not mentioned by your brother.
Lordship, the document that they have submitted, their same documents have been submitted, Lordship. This was the reason that the records have been called for, Lordship.
See, merely having a document, maybe a document is matching, does not create a relationship.
Lordship.
Neither your brother your uncle introduces you as your relative, nor your father. And in your case also, you have shown the
Yes,
written statement.
Stated, Lordship.
You don't introduce the uncle.
Then Lordship may fix another date, I will satisfy your Lordship.
Then make us read the file again.
Another date, Lordship, I will satisfy your Lordship.
What say that it doesn't complete there, make that upload. Okay, this form, it will take 6 or 7. Exactly. But sir, Payang, you make a note of yourself. We may not remember on that day.
Yes, ma'am.
Take a note of what we are looking for. Team today is record. Every time you won't remember.
Thank you.
Okay, this item 11.
Yes, Lordship.
Oh, item 10. 10 we forgot. Yes. None appears on call for the petitioner. All the respondents are represented or inter the matters can come today. Next, we take note of the fact that the matter was previously dismissed for non-prosecution. And thereafter, the matter was restored by order dated 14/8/2023. Accordingly, it made clear that if petitioner remains absent on call on the next date of this thing, those orders to follow. Next. By the said order dated 14/8/2023, this court had directed the petitioner to deposit a cost of rupees 2,000 in the account of Gauhati High Court Bar Association Welfare Fund. And the learned counsel for the petitioner was required to show the proof of such payment. Which are not is there. Like, list concept.
6-4.
Item 11. Yes, in this case, your affidavit was not found satisfactory. Have you filed that affidavit? Where is that?
Filed on 25/12.
This we have couldn't read it. We will log on it. Just pick it up some other day. We'll take it up some other day. This is we have not been good. Both sides are represented. To the positive time matter cut off, we taken off for getting. Based again on 7/4/2026. You can go on.
Single bench, item 1.
Lordship, this is a review petition filed on behalf of the state against the order dated 29/5/2019, passed in WPC 4828 of 2013, Lordship. Lordship, here the petitioner, she took part in an advertisement, another person was appointed in her place, and she challenged that before this honorable court. And Lordship, the operative part of the order, page 14, Lordship. Now, Lordship, there is a speaking order which was passed in 17 June 2019. First, Lordship may come to the operative part. Page 14 of the order, second line. Third line, hence for depriving the petitioner of her status as a physically challenged, orthopedically handicapped female, though her identity card does not indicate any expiry date, and consequently depriving the petitioner of her selection and appointment as Anganwadi worker or helper from the year 2013 onwards till date, this court is clearly of the view that a remedy in public law for granting of remedial compensation is required in the present case in hand. Hence, this court is inclined to pass the following directions. Number 1, that the State of Assam through the Commissioner and Secretary to the Government of Assam Social Welfare Department, Respondent 1, the Director Social Welfare Department, Respondent 2, the Child Development Project Officer, Hajo ICDS Project, Respondent 5, shall pass appropriate orders so as to appoint the petitioner as Anganwadi worker under reserved category of physically handicapped persons in the vicinity. That, Lordship, is already done. She was appointed way back on, Lordship, 18/6/2019.
Number two, Lordship, this is important, Lordship, for not adhering to 3% reservation as earmarked in the advertisement bearing so-and-so dated 25/6/2013, and by depriving her of her selection and appointment on untenable ground, this court is inclined to impose a compensation of 4 lakhs to be paid by the 3 respondents indicated above, jointly and severally to the petitioner within a period of 2 months. Lordship, we had filed an additional affidavit in the WPC, where Lordship, the stand was inadvertently not taken as to the delay caused by the then CDPO for not granting her that appointment, Lordship, to the petitioner. That is why, Lordship, we have filed this review for the compensation amount of 4 lakhs imposed on the respondent. That is, Lordship, very high, and we are praying for exoneration of the said amount, Lordship, by way of filing this review petition. Otherwise, Lordship, this is the speaking order by which, Lordship, the writ petitioner has already been appointed as Anganwadi helper. Lordship, this is the speaking order. In pursuance, in compliance to the order passed in WPC.
Dismiss the matter. He was appointed in speaker of.
Lordship may peruse the speaking order, second page. Third last paragraph. As materials on record, it has been observed that the respondent Runuma Begum, which was earlier selected, was illegally engaged as Anganwadi helper in 2 number Diharkuria Anganwadi Center under Hajo ICDS project by the project level selection committee. Yes, Lordship. She has been removed, Runuma Begum.
This honorable court. This honorable court state the matter accordingly. Runuma was reinstated in this case. That is why, Lordship, on last occasion, that petition dismissed, which was taken with dismissed.
Lordship.
This is incorrect, no?
Because, Lordship, I was given this instruction some time ago only, Lordship. That is why I am on of the impression. Yes, Lord. If that is the case, Lordship, I have to go into it because this has been given to me only some time ago that this person has been removed. Lordship.
My lord, as your lordship know that my lord, earlier petition was filed by Runuma Begum. As she was not heard, that has been said before the court, and honorable court take the matter. This order states.
Number two of Lordship.
4617 minor. That is filed by Runuma Begum, and that was stated. Well, my lord,
17. 2017. Lordship, but this order judgment.
At least somebody can say the TCS of the case, because last occasion Madhusudanam appeared, then thereafter she appeared. At least somebody take the responsibility connecting the matter. Yes, yes.
No, Lordship, only one submission, Lordship.
Which one, my lord? This.
Lordship, this Runuma Begum filed WPC.
Then, अपने review जितो ऐसे against Hadaya Begum from the start.
Yes, 13.
Yes. 4 days later.
19 হ'ব তেতিয়াহ'লে Lordship may give me 1 week's time, I will. Otherwise, my lord, if no further instruction is forthcoming, then Lordship may direct for personal appearance also. You shall. Government advocate. A date may be fixed, Lordship. Obliged, Lordship.
Item 2.
May I please, your lordship? They has been filed, your lordship. Seeking amendment to cost title to include the respondent number 3 with correct address and nomenclature. Much of it.
Item 3.
Now, in this case, my lord, I'm extremely sorry, my lord. I may be granting a week time, my lord. They filed my lord, objection, so I couldn't get the instruction. I'm extremely sorry, my lord. My lord, bless you. I'm grateful, my lord.